Hello everyone, my name is Shibani Ghosh. I'm a lawyer. I specialize in environmental law and I practice in courts in cases dealing with environmental issue. I'm also involved in research and writing, and I'm associated with the Center for Policy Research, a leading think tank based in New Delhi, where my work involves environmental law and regulation in India. And I've also worked with the Central Information Commission, which is an apex body under the Right to Information Act 2005, and some of my research and writing is on the right to information. The module that we are going to discuss today is the judicial remedies that are available in environmental cases. Now, as you know, environmental governance and environmental decision making has several direct and indirect implications on the rights and interests of stakeholders. For example, a decision to build a dam or a decision to mine a particular quarry could lead to certain types of air and water quality repercussions. There could be a decision to clear forests or to mine or to build industries or to dispose of wastes in a certain way. Or there could be certain form of inaction by the government, which decides not to do anything when it sees forms of environmental degradation. All these different implications lead to different kinds of consequences. And these consequences require some form of grievance redressal. While some grievance redressal can happen at the appropriate executive level, a lot of it really happens from the judiciary. So in today's class or in today's discussion, we are going to look at what are the remedies that the judiciary offers in environmental cases, or cases where there have been violations of environmental law, or cases where there has been environmental degradation and the lives and interests of people have been affected. Now, the outcome of this module, or by the end of this module, I hope that some of you will be able to understand what are the different courts, or what are the mechanisms that are available, starting from the National Green Tribunal, which is a specialized court for environmental cases, moving on to the lower criminal courts also, where certain kind of environmental crimes can be prosecuted, and then finally the higher judiciary, which constitutes the high courts and the Supreme Courts. Now, we will begin with the National Green Tribunal, which, as I said, is a specialized court or a specialized tribunal which hears and decides only environmental cases. The National Green Tribunal has been set up under the National Green Tribunal Act of 2010. The Act provides effective and expeditious disposal of cases as its objective. Disposal of cases, of course, relating to the protection of environment, including the enforcement of any legal right relating to the environment. Now, the National Green Tribunal is not like any other judicial body. It is actually a multidisciplinary body where there are judicial as well as non-judicial, or what we call expert members. These are people who have expertise or technical knowledge in various fields. They could be professors from universities, they could be retired bureaucrats, they could be people who have specialized knowledge in fields such as hydrology or sciences or social sciences. So these people are expert members in the body. Now, the National Green Tribunal actually replaced a body which existed before that, which was called the National Environment Appellate Authority, which had a similar but much limited mandate. The National Environment Appellate Authority could only be approached if you wanted to challenge an environmental clearance that has been granted to an industry. However, in the case of the National Green Tribunal, it has a much broader mandate, which we will discuss in just a bit. Now, what are the cases that can be brought before the National Green Tribunal? Or in other words, what is the jurisdiction of this tribunal? Now, the jurisdiction of the National Green Tribunal can actually be divided into two, which is called the original jurisdiction and the appellate jurisdiction. What is the difference between original and appellate jurisdiction? Now, original jurisdiction refers to the powers of the tribunal to decide an issue for the first time before any other authority has actually made a decision on it. In comparison, in appellate jurisdiction, what the tribunal does is it sits in hierarchy, in a higher position than an authority which has already taken a decision. So someone approaching the tribunal in an appellate jurisdiction is actually challenging a decision or an order by another authority before the tribunal. Now, cases which fall under the jurisdiction of the National Green Tribunal cannot be heard in other courts, which means that if the National Green Tribunal can hear cases, for example, challenges against environmental clearances or forest clearances granted to projects, the cases can only be brought to the National Green Tribunal, and most likely judges in the Supreme Court or the High Courts will not accept such cases and will request petitioners to approach the National Green Tribunal. Now let us look at these two types of cases, under the original jurisdiction and the appellate jurisdiction, more closely. In the original jurisdiction, which is under Section 14 of the National Green Tribunal Act, all civil cases where a substantial question relating to the environment arises out of the implementation of 7 environmental laws can be brought before the National Green Tribunal. I must emphasize these are only civil cases, so criminal cases cannot be brought before the National Green Tribunal. Now, what are the 7 laws that we are looking at? These are really the 7 most important laws, with the exception of one, which I'll come to in just a bit. The laws are with regard to Water Prevention and Control of Pollution Act and the Cess Act in regard to that. The Forest Conservation Act, under which forest clearances are often granted to project proponents to be able to use forest land for non-forest activity. Air Prevention and Control of Pollution Act, often known as the AIR Act. The Environment Protection Act, under which several other notifications and bylaws and rules have been issued, whether it's regard to the environment clearance process or regulation of plastics, electronic waste, hazardous waste, municipal waste, coastal regulation zone. All these come under the ambit of the Environment Protection Act and therefore under the ambit of the National Green Tribunal. The Public Liability Insurance Act 1991 and the Biological Diversity Act of 2002. The notable exception, which is not under the jurisdiction of the National Green Tribunal, is the Wildlife Protection Act of 1972. One of the reasons given for that, and though there's no unanimity on it, is that the Wildlife Protection Act concerns mostly criminal cases, and since the Green Tribunal does not hear criminal cases, it wasn't brought within the ambit of the National Green Tribunal. As you can see, the notable exception to this list of acts is actually the Wildlife Protection Act of 1972. While there's no unanimity, but people say that one of the reasons why the Wildlife Protection Act has been kept out of the jurisdiction of the National Green Tribunal is because it mainly concerns criminal offences and not civil offences or civil cases, which are only the type of cases that the National Green Tribunal can consider. Now let's look at some of the examples of cases that can be brought before the National Green Tribunal in its original jurisdiction. So if there is an industrial complex which is leading to massive air and water pollution, there's groundwater contamination, then petitioners, who could be people who are affected by it or NGOs, could approach the National Green Tribunal challenging the environmental impacts of this industry as a whole. The difference is that they are not challenging a particular consent or a particular clearance granted to the industrial complex, but the whole environmental impact of the complex. Another example could be, as some of you perhaps know, the floods of Uttarakhand in 2013 and the massive impact that the floods had in livelihoods of thousands of people. A case has been brought before the National Green Tribunal in its original jurisdiction, challenging the contribution of irregular and unauthorized construction along the river valley, which led to massive destruction. And a third example is the rampant sand mining, rampant illegal sand mining that has been taking place across the country, which has been challenged before the National Green Tribunal to protect the beds, the river beds, which are getting affected by this form of illegal mining. Now, the decision of the jurisdiction of the National Green Tribunal also includes a direct violation of a specific statutory environmental obligation by a person, which affects the community at large, or substantial damage to the environment or property, or damage to public health which is broadly measurable. If any of these criteria are met, whether the environment is affected or then the people are affected at large, or there's a specific environmental obligation which has not been met, then the National Green Tribunal's original jurisdiction can be triggered. The environmental consequences of a particular activity or measure could relate to a specific activity or a point source of pollution. So, for example, a particular factory would be a point source of pollutant such as sulfur dioxide or nitrogen dioxide. Now, the applications that are filed before the National Green Tribunal under its original jurisdiction have to be filed within a particular time limit, which in law is called a limitation period. The limitation period for these kind of applications is within 6 months from the date on which the cause of action for such dispute first arose. So, which means the first time on which the petitioner or the person bringing the case to court notices pollution, he or she or the group has 6 months to bring that case to court. If there is an additional period of 60 days grace that can be given beyond the 6 months, so 2 more months. However, the delay of bringing the case to the court has to be explained to the tribunal, and if they are satisfied that there was sufficient cause for delay, they may allow the case to proceed. However, if the case is brought beyond 6 months and 60 days, that is 8 months, then this case cannot be filed before the National Green Tribunal.